many thanks to the Deers Community Foundation for all you do behind the scenes. It's really been great support for the council. And I think everybody should have a little insight into what happens. We actually have a rehearsal for this. And you can imagine trying to herd the cats of getting everybody together at the same time. So many thanks to Mara for herding the cats and getting everybody's schedule together and letting us rehearse. So there's a lot that goes on behind the scenes. Bill Super wanted to make sure that I mentioned that he does not have COVID. So COVID has not repealed the common cold. So I think he just has a little bit of a cold. So I'm sure he'll get better soon, and you'll join me in hoping that he gets well really soon. Now I'm going to turn over to Pete Tentler. Pete Tentler is our sponsor. Pete, if you would just take it away.
Yeah, let me share my screen. You know, Paul, I find it ironic that I could be this month's sponsor when the main topic today is elder abuse. And I say ironic because people have said that I prey on old people. Usually, these are people that have a misunderstanding on how the reverse mortgage works. For example, not too long ago, a gentleman told me, he said, the reverse mortgage is designed to swindle the senior borrower and their home and swindle it away from their heirs. So I asked him, I said, can you explain to me how you describe the reverse mortgage process to your clients? And he says, number one, the house has to be free and clear. Number two, you sign title to the home over to the lender or the bank. And in turn, the lender pays you a mortgage payment for the rest of your life. But when you die, the lender gets the house and all the remaining equity, leaving the heirs with nothing. So I said, but politely, please allow me to explain how it really works. First of all, your home does not need to be free and clear. In fact, most of the time, the borrower is just looking to get rid of a large mortgage payment. You always retain title to the home. You have the option of taking a monthly payment, taking a lump sum payment, or leaving it on the credit line, or just taking a combination of all three. It's very flexible. Finally, your heirs will always inherit the home and keep all the remaining equity after the reverse mortgage is paid back. This gentleman then said, you know, I wish I knew about this before I talked my client out of getting a reverse mortgage several years ago, only to have them lose their home to a foreclosure about 2 years later. And by the way, this gentleman, I'm not going to mention his name, you might know him. He's been an estate planning attorney for over 25 years and often frequently made the council meetings. The good news is that I explained to him how it works, and now he's sending me business on a regular basis. There's one thing I want you to take away from this meeting is this. Any questions, anytime. I'm available for you anytime. Another example is I get random phone calls from attorneys or financial planners saying, hey, my client died, they had a reverse mortgage, and now their heirs are getting letters of threats of foreclosure, or the reverse mortgage balance is now exceeded of the value of the home. What happens next? And I explained the process and how it works. And what's kind of funny is they say, all right, send me an invoice for your time. Now, I don't charge invoice for your time. Now, I know not everybody can give free advice, but that's how my process works. I want you to feel comfortable calling me whenever you have questions about this. I don't expect you to be experts in reverse mortgages. That's my job as an advisor, such as yourself. I promise I will make you feel comfortable with your questions anytime. So one of the first things I always talk about with advisors or their clients is the myths versus realities. Now, I covered most of them already in that one scenario. So the ones that we didn't touch base was the loan proceeds are taxable income, or it's only for poor people. Now, many financial advisors recommend the reverse mortgage as a hedge against future expenses such as medical attention and asset protection strategy. And that's how the reality of the reverse mortgage works. I'll go into a little bit more detail on that in just a second. I've already talked about the disbursement options. They can take monthly payments, whether it's a short-term or long-term, or a combination, or just as I recommend, if you don't need to borrow the money, leave it on the credit line, because the credit line has something very unique called the growth rate. Whatever is available on the credit line, that credit line will increase every month at the current interest rate. So in this example, the annual rate plus the MIP all in is about 2.5%. In this scenario, the borrower is 62 years old. He's got a credit line of $400,000 and will increase every month, regardless of the home value. Goes up, goes down, it will still increase. So 10 years later, at the age of 72, he has a little over $520,000 available to him. And in 25 years, now he's 87 and has access to over $700,000 on the credit line. This will allow him for a lot of long-term care costs, such as in-home care, without having to pay expensive long-term care premiums. And this is where I want to make you look good in the eyes of your clients, to make sure that you had the foresight to set up this reverse mortgage credit line earlier than later. Real briefly, there's two primary reverse mortgage available that I offer. The FHA home equity conversion mortgage, I'll call that the standard mortgage, versus the proprietary, also known as the jumbo. There's two limitations here. They're both non-recourse loans, which means they will never owe more than what the home is worth at any time. The main difference is that the standard will cap the value of your home at $822,375, whereas the jumbo limits the home loan amount to $6 million. The standard is FHA insured, so it will have higher closing costs due to the mortgage insurance premium, whereas the jumbo is not FHA insured, so it will have lower closing costs. The standard will have a lower interest rate, where the jumbo is going to be higher. But a quick demonstration is that if a 62-year-old will get about 52% loan to value of their home, if the home is appraised at $1 million and they do the standard reverse mortgage, they're only going to get 52% of $822,000. The standard reverse mortgage age requirement is 62, whereas the jumbo is 60. Deciding which option is best for your client usually requires plenty of discussion on what their goals are in retirement. It's not as simple as whether their home value is north or south of the lending limits. Many advisors, even realtors, are unaware that you can use the reverse mortgage to help finance the purchase of a new home. In this brief scenario, you have a couple that are 72 years old. They're eligible for a loan amount of $411,000. They wanted to downsize their existing home and buy a new home with all cash, so they didn't have a mortgage payment in retirement. The problem was they were reluctant to sell because they were only going to net $350,000 from the sale of their home. The only homes that they liked that they could pay all cash for required them to move out of San Diego County up to Riverside County, or perhaps out of state, which was a compromise. As you can see in this scenario, they were able to purchase a home for $700,000 with a $305,000 down payment. And because it's a reverse mortgage, the mortgage payment is zero. This is what I call right size without compromise. Another scenario for larger loan amounts. But in summary, I'd like to just tell everyone, remember, this is a very useful cash flow tool. You have an option with the credit line growth rate for opportunity for future borrowing power. It relieves existing debt, monthly mortgage payments. You can purchase a new home, right size, to a more manageable home and community. A key strategy in asset protection planning It's flexible with the payments options, and it's safe. Both are non-recourse loans and both require consumer counseling. That's about all the time that I have for the sponsors. I want to keep it brief because I really want to listen more about the elder abuse. But again, any questions, anytime. My phone number is right here. I did not put my email address. I guess I should have. But my name is Pete Tentler. I'm a certified reverse mortgage professional. And some people call me the financial locksmith because I can unlock the equity in your home so you may secure your financial future. Thank you for this opportunity.
Thank you, Pete. Pete is a tremendous resource for San Diego and all the professional advisors in San Diego. I can't say enough about how much I've depended on Pete to be an expert in this area. And also thanks to Pete for running the Trifecta program and being a member of the board. So I recommend everybody put Pete's phone number right in your phone. I've used it very often, and it makes us feel very comfortable to know that we have an expert, and makes us look pretty smart to our clients. So thank you, Pete, for all you do. Really appreciate it. Okay, I'm going to mention, since I mentioned the board, of course, Bill Super is our fearless leader. He just does a tremendous job putting on these programs. Also, David Jacobs, Phil Sullivan, Carly Harmonson, and of course, as I've mentioned before, Pete Tentler. So thanks to all the members of the board. I'll also mention thanks to Roberta Robinson and Dan Wilson, who help the professionals get their credits for these meetings. So thanks again to them. And I want to thank our panel today. So we're going to go right into the panel. And when I was asked to put this panel together today, I had these three people on the top of the list. And luckily everybody was available. Their dance card was empty for this time of the day. So I really appreciate everybody being here. And most of them don't need an introduction. They've been
Paul, you're muted.
How'd that happen? How long have I been muted?
Not long, just for a moment as you were introducing your panelists.
Okay. That's funny. Little gremlins in the system. Okay, so I'm going to mention the panelists. We're going to start with Amy Wasak from Adult Protective Services. Good morning, Amy. And then we'll go to Rob Derringer, an elder abuse attorney in San Diego. And we'll wrap it up with Paul Greenwood, the retired Deputy District Attorney. So today's topic is elder abuse. Elder abuse is not a very comfortable topic to discuss. It's a despicable act, but we need to talk about it because we need to help raise awareness. And that's the goal of today, is to help raise awareness, elevate the topics that need to be thought through and discussed, and hopefully if we can raise awareness, we can try to help stem the problem. So Charlene, I don't know if you want to start the slides for the presentation for today.
Yeah, would you like me to start with Amy?
Yes, please.
Okay, coming up.
Start with the first slides, if you would.
Great, thank you so much. Well, I know I have a limited amount of time. I could probably talk about this for 8 hours or more, but I'm going to just do a very brief overview of what we do. And I'm going to focus on the financial abuse piece because I think that's really what our focus is here today. So I'm a supervisor with Adult Protective Services with the County of San Diego. I have over 21 years experience, and actually in my career, I had the privilege to work with Paul Greenwood, our elder abuse DA, who's with us today. I see he's still active. And I have a lot of experience, and I've seen every kind of financial abuse you could possibly imagine. And the financial abusers continue to be savvy and innovative in finding new ways to financially abuse people once law enforcement is on to them. So what we do APS, we investigate elder abuse, and that includes financial abuse, physical abuse, verbal abuse, neglect, and self-neglect, and some other things as well, isolation. We do see kind of a strong link between the financial abuse and the self-neglect piece. Okay, next slide. So I just want to let you know, we are social workers. We are not attorneys. We are not law enforcement, but we work with law enforcement. We cross-report to law enforcement. And I'll get a little bit more, talk a little bit more about that when I talk about what we do. So I kind of went along with today's agenda, which is spotting the problem and then assessing and then intervening. So spotting the problem, we get reports, people report to APS, Adult Protective Services. And in the realm of financial abuse, financial institutions are mandated reporters. That was a law that was passed years ago, I think in 2009, that financial institutions became mandated reporters. So we get lots of referrals from banks, credit unions, and also other kinds of financial organizations, investment firms, things like that, when they see unusual transactions happening. So what kind of things tip off the bank that there's a problem? Unusual or suspicious transactions, things that are out of the ordinary spending. For example, an elder person who's never used a computer or paid a bill online, now all of a sudden there's all kinds of electronic payments. Any kind of wire transfers of money from one account to another, large transfers, anything out of character. A customer who seems confused about their accounts or their transactions, a customer who doesn't remember a large transfer, or who is accompanied to the bank by a new person who wants to get them to change their account or add them as a beneficiary or add them as a joint account holder. We've even had referrals where a perpetrator impersonates a banking customer over the phone to try to get to accomplish a transaction. Okay, next slide. Yes, please do type your questions because I can't really see you all now. I'm just kind of focusing on this PowerPoint. And thank you so much, Charlene, for helping me with this. So what kinds of types of financial abuse cases do we see? We see so many kinds. I wouldn't even have enough time to tell you all about them right now, but I am going to touch on some of the main ones. I'm going to give you a couple examples. So we see scams. Many scams, romance scams or sweetheart scams, account takeover scams where someone clicks on a link that looks like it's from Microsoft technical support, and the next thing you know, they've taken over the computer and they can go into the banking information and transfer money. I'm not quite sure how they're able to accomplish this, but they do. We see, okay, so lottery scams, those are kind of old school, but they're still around. Money Mule, where they actually are getting our seniors to actually participate in the illegal transfer of funds. The grandma or grandpa, I'm in jail scam, and you need to wire money to this consulate in wherever to get me out of here. Anything pay us in gift cards. Anything that involves paying in gift cards, we're seeing that all the time. We're getting so many referrals about that. An example, I try to give a quick example of each type of scam or each kind of financial abuse. We had a guy, this was a couple years ago, who was involved in a romance scam, thought that he was really in love with this woman. This woman, who was actually a guy in Nigeria, was not even a woman, but was sending pictures of a beautiful woman. He basically lost everything he had, including he refinanced his house, every bit of money that he could get, maxing out credit cards, whatever, he sent it all to her, or him, I should say. He actually flew to New York City to meet this person. Of course, they were a no-show. He ended up committing suicide in his garage here in San Diego. So just to show you how extreme, how deep into these scams people get, where they, and everyone tried to tell him this was a scam. APS told him this was a scam. Law enforcement told him this was a scam. The bank told him this was a scam, yet he was in it so deep that he just couldn't find his way out of it. And so there's a big emotional component here, with people being very, lonely and needing that companionship and not finding it in the right places. Okay, estate planning, financial abuse. So that's probably what you're all seeing more often. What does that look like? Perpetrators are usually family members or some other new friend, new caregiver, neighbor who's going to swoop in to help. What kinds of things do you see with this? And this is kind of the red flags that you're probably going to be noticing. Any kind of estate plannings that seems to be made when the client's capacity is in question, or they're not understanding the changes that are being made. Or you can see signs of undue influence, and we're going to define and talk about undue influence today, and the attorney is going to talk about it even more from a legal standpoint. I have a quick case example if that's more interesting. We had a client last year. It was an elderly lady, female client, who had a pretty good estate, a little bit geographically isolated, so kind of out away from neighbors on a private property that was gated. She did not have any children or family or spouse, and she lived alone. She had some dementia or neurocognitive disorder. That's the same thing, by the way. I'm going to talk about that today too. Neurocognitive disorder is the more correct term for dementia. She has a gardener / handyman guy who's helping her do things around the house, and then he really starts to get involved with her life. And he creates this dependence where she feels dependent on him because she knows she needs help to live independently. So he's promising her that he can help her stay in her property, not go into a nursing home, help her with her bills because she was getting confused. She starts to feel very dependent on him. And this is this whole dynamic of undue influence here. She issues him a cashier's check for $47,000, which the bank is suspicious of and refers her to APS. So APS, we go out to assess her. She can't tell us why she gave him $47,000. She can't remember. She barely recalls it. She has a vague recollection. And she's actually set up a transfer to transfer $100,000 to him because he's going to invest that in a restaurant, or supposedly going to invest that in a restaurant. So APS calls law enforcement. They arrive at the home and actually were able to stop the $100,000 from being transferred, and we got the perpetrator to give her back, to return to her the $47,000 that she had given him a cashier's check for. So we ended up bringing in a psychologist to do a capacity declaration, who found her to have neurocognitive disorder or dementia, and said that she was unable to manage her affairs. We found out that there was a trust. We got in contact with the attorney for the trust, who was able to put the trust into action, appoint a fiduciary, and now she has a responsible fiduciary managing her finances, and has also hired in-home care for her so that she can remain living in her home for the rest of her life. So that is an example of an APS intervention into these kinds of estate planning, undue influence. Not all of our cases turn out that well, but that was an example where everything just kind of worked together. And then there is parasite financial abuse. And yes, I made up this term myself. I didn't invent the term parasite, but I call it parasite financial abuse, and you can probably guess why. Basically, financial dependence on the client. And I found a great description of parasitic lifestyle on the internet. It says an intentional, manipulative, selfish, and exploitative financial dependence on another, as reflected in a lack of motivation, low self-discipline, and inability to complete responsibilities and maintain self-sufficiency. And usually drugs and alcohol are involved. All right, next slide. Thank you, Charlene. I'm going to give a very brief overview of neurocognitive disorder. And the reason I'm talking about this today is because neurocognitive disorder makes people more vulnerable to financial abuse and exploitation. Whenever you hear the word dementia or Alzheimer's disease, those are types of neurocognitive disorder. So Alzheimer's disease is the most common type of neurocognitive disorder, but there's also other kinds of dementia that are not Alzheimer's, such as dementia from having strokes, and there's also alcohol-induced dementia. People that are lifelong alcoholics can sometimes have dementia induced from alcoholism. And there's some dementias with some other disease processes too. Okay, next slide. So why do we focus on neurocognitive disorder in APS? Because it makes people more vulnerable to financial abuse and exploitation. The confusion. I'm going to talk about the executive functioning. So executive functioning is a person's set of cognitive processes in the brain that help a person focus, remember or recall, reason, problem solve, regulate emotion, and integrate information. So you can imagine that if you're trying to make an important financial decision, if your executive functioning is impaired, you can imagine how that would affect your ability to make a good decision. What you might notice in your client that there are, and we're going to have another slide on the red flags, but you may notice this confusion or forgetting appointments, or more than likely a family member or another concerned person is going to alert you that there's an issue, because a lot of times people with dementia don't have insight and they don't recognize that they have a problem. All right, next slide. Okay, so I am not a doctor, but I'm just giving you this slide to show you what the official diagnostic and statistical manual describes. There's major neurocognitive disorder. A lot of times you may see that your client has unclear or fluctuating capacity. Sometimes they have good days and bad days, and your family may tell you they have good days and bad days. Some days they're pretty clear and can remember and talk about stuff, and then other days they may seem more confused. So I won't read the symptoms to you. You can see this is a cognitive impairment. And what you may notice is memory loss, forgetfulness, getting lost. Maybe if they tell you they got lost on the way to meet with you, that could be a red flag, or they couldn't find their way home. Disoriented, lack of awareness of their bills or finances, trouble finding the words, confusion, a decrease in overall functioning. So if you're not seeing them at home, it may be hard to see this, but what we see when we go to homes, they're not able to manage their medications, or they don't have any food in the house, or bills have not been paid, those kinds of things. You'll also see some behavioral changes. And then this overall concept of self-neglect, which is what gets us involved, is when people just aren't taking care of themselves anymore and they just can't manage anymore. Okay, next slide. All right, so red flags, what to look for. And this is kind of with a focus on financial abuse. Money being transferred or wired, always a red flag. Unusual transactions. The person lacks awareness of their financial affairs or estate plan, or they don't understand changes that are being made. There's frequent changes. We see that too, where you have competing beneficiaries. Leave the money to me. No, leave the money to her. Oh, she messed up, so I should take her out of the will, or this or that. So all these kinds of changes can be a red flag that there's something going on. It could be undue influence, family dynamics, or it could be cognitive impairment. And then red flags about the client being scammed, any kind of scam stuff like what we talked about, gift cards or winnings, or I'm going to win big on this, or I have to wire money, any of that kind of stuff. All right, next slide. Okay, APS gets called. The first thing we do is we call the reporting party to clarify the information and to get more information, to clarify the concerns and find out if there's any updates. We assess. So back pre-COVID, we did mostly unannounced home visits where we actually went to the home unannounced and knocked on the door and asked to speak to the client because we didn't want them to get coached or prepared prior to our visit. With COVID, we have been doing a lot more phone calls, which I don't think is the best way to do business because I think there's a lot that we can see when we go in person. So hopefully we'll be able to get back to face-to-face visits here in the near future as these vaccines roll out. It's very important for us to interview the client privately. As you might imagine, if the suspected abuser or the person that's exploiting them is present, we're not going to be able to get a very clean interview. So I know that attorneys often interview their clients privately to make sure that they're clear about their wishes, and we do the same. If there's any question about their capacity, we will try to get a capacity declaration. That could be by a doctor, or sometimes the doctor will refer them to a specialist. And if we're not able to do that by their own provider, we will sometimes bring in a psychologist that we contract with to do a capacity declaration, completely independent, unbiased capacity declaration to let us know what diagnosis that person has and whether or not they're able to manage their affairs or not. And then what else do we do? What are our interventions? Well, I gave you an example of one where we brought in law enforcement, and law enforcement was able to get the person not only to return the money that he had accepted from her, but they squashed that $100,000 transfer. We are legally mandated to cross-report confirmed elder abuse to law enforcement. So we cross-report to law enforcement depending on the jurisdiction, whether it's the sheriff's department or the city, such as SDPD, Oceanside PD, or whatever jurisdiction. We do sometimes recommend legal services or give them referrals to the senior legal services, elder law and advocacy, or sometimes they have their own attorney that they'd like to consult with. We have to be very careful about not referring anyone to a particular attorney. We usually provide a list of legal resources. And we do also sometimes refer to the public guardian if warranted, and we collaborate with involved community partners. So who do we talk to? We can talk to whoever we need to investigate financial abuse or elder abuse. We sometimes talk to the bank, the financial people, the family, the caregivers, the doctor. It just depends on the case. So that's an idea of what we do. And at the end today, if you have any questions about that, thank you, Charlene. Undue influence, I think Rob is going to talk more about this. I just grabbed this definition off of Wikipedia. It's basically think, power, control, dependence, a person who becomes a dependent on another person. With our elderly people, sometimes they are promised by this person that we'll keep you from going into a nursing home. I'll take care of you. I'll make sure you're okay. And then we see these other red flags of financial access. There's usually some kind of vulnerability involved here. The client that has, perhaps they have no family, or they don't have children looking out for them, or they have cognitive impairment, or they've lost a spouse who managed everything, and they don't know how to manage things, and they want to continue to live independently. They don't want it to go into a nursing home. So you have this dependency piece, and then you have this person who comes into the situation who is going to help them or manage everything or keep them out of a nursing home. And then we start to see the red flags. Maybe they're being added to the bank account. I am almost finished. Estate planning changes, beneficiary changes, quitclaim deeds. So yeah, so that just about wraps it up for me. I know I went really fast and I apologize for that. I know we have a limited time today and we have other panel speakers, but I'd be more than happy to entertain questions at the end or whenever that is appropriate. Thank you.
Thank you, Amy. Our heart goes out to you and all of your coworkers because we know that you deal with this every day, and it's not easy. And I think your terminology of parasite is perfect because the people that do this are one of the lowest forms of human life, right? I do have one question that came in, and maybe you can unmute yourself. Are there any legal concerns with providing personally identifiable information to the APS law enforcement if pertinent to concerns around elder abuse?
No, there's actually a welfare and institutions code that says that any person, professional, or mandated reporter should and can provide information and details if it's pertaining to that client's safety and pertaining to the elder abuse. So I've never, in my 21 years of doing this, over 21 years, I've never seen a financial person prosecuted or charged with any kind of violation of confidentiality for sharing information that was relevant to that person's safety.
Thank you, Amy.
You're welcome.
Our next panelist is Rob Derringer with Green, Bryan, and French. And I know Rob's bio is very long and impressive, but two things that stood out for me is he's a certified specialist in elder law and estate planning. And that's pretty rare to have both of those things. So Rob, if you'd take it away from here.
Thank you, Paul, and thank you, Amy. That was a really great introduction, Paul and Amy, to the topic of financial elder abuse litigation in probate court and civil court. And this topic is particularly relevant for everyone here today because there are remedies in civil court and probate court that are simply not available in criminal court. And there may be situations, in fact, as a trust and estates and civil elder abuse litigator, I constantly run into situations in which clients say, why are the police not doing anything? Why are charges not being filed? What's going on here? This person is clearly abusing my loved one. And my response often is, well, it doesn't appear that there is a remedy in criminal court because of the beyond a reasonable doubt standard that the DA needs to meet. And I don't want to put any words into into Paul's mouth, Paul Greenwood, who will be presenting after me, but this seems to be the crux of the issue. In civil court and in probate court, you have a lower burden of proof that really avails clients of a much greater variety of remedies when they're dealing with their abused loved ones. So that will be the topic today for my presentation. What can be done in these other venues? What investigations can be done? What remedies can be obtained in civil court and in probate court for the financial abuse of an elder? This is my biography, and I'll let you read it on your own time. So the launching point for my presentation is found in what we'll call ADACPA, the Elder and Dependent Adult Civil Protection Act. And I highlight the word civil because this statutory tort of civil elder abuse found in the Welfare and Institutions Code can only be prosecuted in either civil or probate court. And the definition of financial elder abuse found in ADACPA is found under Welfare and Institutions Code Section 15610.30. Under 15610.30, I think the important things to understand and highlight are that financial elder abuse involves the taking of property of an elder for a wrongful use with the intent to defraud or by undue influence. So wrongful use, intent to defraud, or by undue influence. You also can assist the wrongful taking achieved by any of these various means. And wrongful use, I think, is probably the most interesting predicate finding that can give rise to a finding of financial elder abuse, because it requires proof that the wrongdoer knew or should have known that what they were doing was harmful to the elder, knew or should have known. And this is interesting because it involves a sort of negligence standard. It involves someone doing something that they really didn't know was wrong, but should have known was wrong, and thereby imposing civil liability. This is not an intentional tort. It's something that involves a lower level of scienter or mens rea. Also, you don't need to prove outright fraud. Just an intent to defraud is enough under ADACPA. And then, of course, you have this concept of undue influence. I would say that the vast majority, 90% or more, of the financial elder abuse cases we're litigating in civil and probate involve undue influence. And undue influence is the excessive persuasion that causes another person to act or to refrain from acting by overcoming their free will and results in inequity. And as Amy described before, it's an unequal position of bargaining power or persuasion that one obtains by virtue of being entrusted with another person's affairs. And Welfare and Institutions Code sets forth 4 factors that are relevant in assessing whether or not there's been undue influence. 1, whether the victim's vulnerable. And there are a number of factors that the Welfare and Institutions Code lists as being relevant to vulnerability: age, incapacity, dependence, isolation, and things of that sort. Then there's the apparent authority of the abuser. Things like being a clergy member, a fiduciary, a companion, a caretaker, are all positions of authority or apparent authority that create this unequal position of bargaining power. And then the Welfare and Institutions Code lists actions or tactics that are used to accomplish financial elder abuse or undue influence. So the wrongdoer needs to actually do something. They can't just sit by and benefit. There needs to be some kind of affirmative steps that they take to actually take advantage of their unequal position of authority. And then there needs to be an inequitable result. It can't just be that a caretaker helps the elder obtain a reverse mortgage to no benefit of the caretaker. If the elder benefits from it and there's no inequitable result, that's not undue influence. So these four factors need to be evaluated in assessing whether there's undue influence. There are a variety of presumptions of undue influence that apply in probate and civil contexts. So a lot of us are probably already aware of the drafting attorney or care custodian presumption that requires not the plaintiff or the petitioner, not the person alleging financial elder abuse to prove undue influence, but rather shifts the burden to the person who received the undue benefit to prove that it was not the product of undue influence. So if you have someone who's providing care services to a dependent adult and receives remuneration, meaning payment, it is on them to prove that their receipt of a benefit from the elder or from the dependent adult was not the product of undue influence. The same thing with a drafting attorney. And we certainly run into these cases. Absolutely, in the world of financial elder abuse litigation, is the caretaker a common respondent or defendant in our lawsuits. And oftentimes it's not some pure sociopathy that causes some person to say, I'm going to take advantage of this elder. It seems that in a lot of cases, there's this built up sense of entitlement that someone develops over years of caring for an elder and feeling like, well, these no good kids shouldn't get anything. I'm the one who's wiping the behind, and I'm the one who's living here and helping this person, walk around the house, and I deserve it. And that's kind of a difficult mindset to break through when you're suing someone, because oftentimes they feel really entrenched and entitled to the thing that they've received from the elder. There's also a spousal presumption under the case of Lentz v. Lentz. If two spouses owe each other duties, fiduciary duties and duties of trust. And if one spouse received an unequal benefit from the other spouse, it's on them to demonstrate that the transfer was not the product of undue influence. There's also a common law definition of undue influence that causes the burden to be shifted, where you have a confidential relationship, which means one person reposes confidence and trust in another. You have the person in whom the confidence is reposed actively participating in the procurement of something, and this thing that they procured must constitute an undue benefit. So even if you don't have a care custodian, even if you don't have a spouse, even if you don't have a drafting attorney, you may still have a presumption of undue influence where you have this confidential relationship. Children under the case law have been found to have a confidential relationship with their parents. And so if children procure a benefit, it might be the product of undue influence, and it might involve the shifting of a burden. These theories of undue influence can be litigated in both civil court and in probate court. If they involve a will or a trust or some other kind of instrument that involves surrogate decision-making, you're likely going to have a probate claim. Alternatively, if you don't have a nexus to surrogate decision-making and you're simply suing someone without connection to a trust, a will, a power of attorney, or a conservatorship, you might find yourself in civil court. For example, one trial I had before the shutdown involved a daughter presenting her mom with a deed, telling her mom that it was a power of attorney, and having her mom sign the deed to give the daughter mom's house while mom was suffering from Alzheimer's and had suffered from Alzheimer's for the past several years. In that case, we didn't have a connection to a will or a trust or anything like that. So we had to file a quiet title, cancellation of deed, and rescission and restitution complaint in civil court to have that deed canceled. And here is some case law and some statutory law on how civil causes of action can be supported by findings of undue influence and fraud. What about incapacity? What if there isn't any wrongdoing and someone simply has procured an undue benefit because the person didn't know what they were doing? I had this one case where it seemed that the elder was able to manage his or her affairs on I'm being ambiguous there as far as the gender to not disclose anything that I shouldn't be, was able to manage his or her financial affairs on an everyday basis, but was suffering from some kind of a delusion that made him or her believe that her family members were, or his or her family members were out to get her, and that there were people who were trying to steal her belongings, and that her bank accounts were being pried into, and made some testamentary decisions based on a delusion that weren't based in reality. And where you have situations of pure incapacity that don't involve wrongdoing by anyone, both the probate code and the common law offers relief on the basis that one of the essential elements of delivery of a deed or a gift, a donative transfer, is the present intention to part with the item conveyed. And without that intent, you might be able to back out a transaction based on pure incapacity without any wrongdoing. We've got limited time today, so I'm going to sort of breeze through this and encourage everyone to review their materials in their private time if they'd like to understand more about the burden of proof in civil versus probate. Generally speaking, case law supports the application of a clear and convincing evidence burden of proof when seeking to overturn testamentary instruments like wills or trusts. But the statutory tort of financial elder abuse specifically includes a preponderance of the evidence standard, and under the Welfare and Institutions Code in a case called Mahan v. Charles W. Chan Insurance Agency, the taking by a donative transfer or a testamentary bequest constitutes the deprivation of an elder's property right for the purposes of a financial elder abuse finding. So what I mean to say is that financial elder abuse statute and related case law may avail practitioners of a preponderance of the evidence standard when seeking to overturn testamentary instruments, the case law regarding the clear and convincing evidence standard notwithstanding. And this goes back to the initial point that I was trying to make at the beginning of this lecture, which is that we have lower burdens in civil and probate. Preponderance of the evidence standard means more or less more likely than not. Was it 51% or was it 49% likely that what happened was wrong? That is far less rigorous than the beyond a reasonable doubt standard. And so in response to some of the questions that I saw in the Q&A, what should be done if you see that there's financial elder abuse going on? Absolutely call the police, but absolutely call a civil attorney, because there is likely in many, many circumstances, a case that a civil attorney can take that the police simply cannot by virtue of this burden of proof. Now, what makes probate court unique? Initially when I started practicing over a decade ago, I thought that probate court was like family court, and it was where you had issues regarding family disputes litigated, but that's not true. I heard Judge Kelledy say that probate court is the court of surrogate decision making, and Judge Kelledy is a really great judge on the probate bench in San Diego. And by surrogate decision making, I mean it's the court where matters concerning one person managing the affairs of another are adjudicated. So in probate, you need a nexus to surrogate decision-making in order to proceed. You need a trustee managing assets for beneficiaries, a power of attorney managing affairs on behalf of a principal, a conservator managing affairs on behalf of a conservatee, or a personal representative managing estate assets for the benefit of heirs or beneficiaries. Without a nexus to surrogate decision-making, you're likely not going to find yourself in probate court. You're going to find yourself in civil. So outright theft involving, hey, mom, sign this deed, you'll likely find yourself in civil court. Beneficiary designations, where there's no argument that the account should have been in a trust. If you're seeking to have one beneficiary designation trump another, you'll likely find yourself in civil court. And again, the predicate findings of undue influence and fraud can give rise to findings that overturn both civil instruments like deeds and direct beneficiary designation forms, as well as testamentary instruments. So I wouldn't get too tied up on which forum. I think that the preliminary analysis is, has there been undue influence, and was this wrong? So to get in the weeds a bit, and I'm going to blast through this, I think, because we've got other people that need to speak, including the headliner, Paul Greenwood. In civil court, you're going to likely, unless you're proceeding on behalf of the elder, him or herself, which is relatively rare, because a lot of times the elder is incapacitated, or at least with diminished capacity, and can't participate themselves. So in civil court, you're likely going to proceed through a guardian ad litem. In probate court, during the life of the elder, you might need to initiate a conservatorship. Upon death, in probate court, you might need to open up a probate estate or proceed through a trust. In civil, you can proceed as a successor in interest or on a number of other statutory bases. Under the Welfare and Institutions Code, you can proceed on behalf of a deceased elder as a personal representative, but if there is none, as a successor in interest, an intestate heir, or as an interested person. And then we get to the topic of commercial financial elder abuse. Commercial financial elder abuse is almost always going to be litigated in civil court. Commercial financial elder abuse, I'm going to define as involving third-party financial professionals rather than friends or family. The most important thing to understand with regards to commercial financial elder abuse is that the duties of the financial institution largely depend on what the act in question was. So, for example, with forged checks, the burden is on the bank to justify a charge on an account made by a forged check. And there are statutes, and there's statutes in the California Commercial Code, and there are case law, there is case law that illustrates this point. Conversely, wires are really tricky. If you've got commercial financial elder abuse accomplished by virtue of wires, the Uniform Commercial Code, as incorporated in the California Commercial Code, precludes any claim that a bank acted negligently in making wire transfers. You might, however, be able to argue that a bank committed financial elder abuse, the commercial code notwithstanding. Financial elder abuse, as we discussed before, is a statutory tort set forth in the Welfare and Institutions Code, and it involves the wrongful taking of an elder's property and also assisting in the wrongful taking of an elder's property. If any of the attendees here today want to dive a bit deeper into that, there's a case called Das v. Bank of America. It's a 2010 case that I've printed here in the materials that goes over what the ability of a private party is to sue a bank alleging of financial elder abuse and violation of the Welfare and Institutions Code. This is a really interesting body of law concerning commercial financial elder abuse. It also generally involves sophisticated counsel on the other end. And so if you do sense that a bank did something wrong in assisting with the perpetration of elder abuse, you might want to contact a civil attorney to dive deep into what the particular mechanism was, because that often is dispositive as far as what the bank's obligations were. With that being said, thank you, and I'll turn it over to Paul Hines and Paul Greenwood. Have a great day.
Thank you very much, Rob. That was fantastic. We do have one question for you that popped up in the Q&A.
Yes.
Do you have any idea of any probate or civil solutions for romance scams?
Yes. So at the start of it, you're going to want to figure out what was taken. And if you have someone posing online as a lover who is seeking the mailing of gift cards, for example, you might have a hard time chasing that person down because the gift cards were mailed to Nigeria or something like that. In cases where you've got a defendant who you can't locate or is difficult to collect from, the best solution might be to initiate conservatorship proceedings in probate court to prevent additional damage. That's often the best case scenario that we're able to offer, is just the limiting of additional harm. Conversely, if it's something that involves the taking of real property and you know where the real property is, then you might sue them in civil court alleging that the property was taken for a wrongful use, that the sweetheart knew or should have known that the taking of the property would have been harmful to the elder. So it really depends on what happened specifically.
Thank you. Obviously, it's a multifaceted problem that needs multifaceted solutions.
Absolutely.
Great. Well, the TV talk show host David Letterman is famous for saying, "My next guest needs no introduction." And I think that's the case here with Paul Greenwood. And Paul has told us, even though he's retired, he's working harder than ever. So Paul, if you would just take it away from here.
Well, thank you very much, Paul H. And good morning, everybody. Thank you to Rob and to Amy. And I'd still call myself a newly retired prosecutor, even though it's now been almost 3 years since I walked out of the DA's office. And for those of you who've not heard me before, you can obviously tell I'm not your classic Southern California dude. I was a lawyer in England for 13 years. First of all, I tried on the white wig and the black gown. That did not go well. So I switched from being a barrister to being a general practitioner called a solicitor. And I still have problems when I walk into a bank when it says no solicitors allowed here. But what can I do about that? So how on earth did I end up in San Diego? Well, it was true love. I had met my wife, who I've been married to for 42 years, in San Diego when I was traveling around in August of 1973. And after 13 years in England, she begged me to bring her back to this beautiful county of San Diego. And I can't blame her for doing that. And I'm thanking her for doing that. When we arrived, I joined a civil law firm for 2 years, but my heart was never in civil law. It's always been in criminal law. And thankfully, in 1993, I got my big break and I was able to join the San Diego DA's office, where I spent 25 fantastic years. So after 3 years in the office, I was called into the boss's office in late 1995, and I was given this assignment. And it all began because he had received a very angry phone call from an agency called Adult Protective Services, who were telling my boss that we as an office and law enforcement in general were ignoring a huge escalating crime called elder abuse. And I turned to the boss and I said, well, what is it? He said, I don't know, but you're about to find out. I said, what or how? He says, because I've just named you as the first head of a brand new unit called elder abuse prosecution. So that began in January of 1996. And typically in my office, we do a rotation for about 3 to 5 years in one specific type of criminal prosecution, whether it be gangs, narcotics, juvenile crime, domestic violence, and then they move you to something else. Well, for me, this became an assignment for the next 22 years. And it's still an assignment in my post-prosecutorial career because it has become very much a passion of mine and something that you don't just leave behind when you leave the prosecutor's office. But going back to January of 1996, here was my challenge. They gave me an office, a phone, a computer, everything a prosecutor needs except one major omission. Nobody was bringing me any cases. I was literally sitting in that office looking at the phone, willing for it to ring, looking at the open door, willing for a detective to walk in with a case, but nobody did. And that's back in 1996. What was the problem? It was silence. And this poster that I borrowed from Illinois became my motivating factor every single day that I went to work. Because I would literally, as I would travel on the bus from Escondido every morning down to 15, I would be thinking this one question: what can I do today to break through this barrier of silence? And that's something that I really would encourage all of us to think about this morning. What can you do in your daily career, your daily routines, to help break this barrier of silence? The folks in Alberta, Canada, has said it well. They've said elder abuse thrives on silence. And not only does the crime of elder abuse thrive on silence, the predators thrive on the silence. And this became a theme when we adopted this campaign called Silence Isn't Golden. And we sent this poster all around the county because we wanted people to realize that this was an untapped crime that was being committed in broad daylight in front of everybody, but we weren't reacting and responding to it in the appropriate way. Now, the silence, as we know, comes from victims. It comes from mandated reporters. It comes from neighbors. It comes from all of us. And we've got to break through this barrier and figure out ways to overcome it. One of the ways is to become aware of the legal stuff. So where do we find the crime of elder abuse defined? It's defined, as most crimes are, in the criminal California Penal Code. And as you probably know, if you talk to cops, they never use words. They only refer to things as numbers. So they'll never talk to you about a murder. Oh no, they'll say, hey, have you heard about the latest 187? They'll never describe a robbery. They'll say, hey, have you heard about 211? Or a burglary, they'll say it's a 459. So why do you need to know the number? 368, because it means the ability. If you suspect that this crime is being committed and you want to make a report to local law enforcement, I guarantee you that the best way to get the attention of law enforcement is, hey, this is a righteous 368. And they're, huh, how do you know that? Now, under that code, we have two specific types of victims. They're defined as elders and dependent adults. Now, dependent adults is any adult aged 18 through 64 with either a physical or a mental disability. But I'm going to concentrate on elders because our title today is Elder Financial Exploitation, and that is anybody over the age of 65. You know, one of the reasons I actually left the DA's office 3 years ago was that my last two cases that I prosecuted, embarrassing for me, my victims were younger than me. I'm just about to turn 69 now. And so I've been an elder for almost 4 years. One thing we have to do with a crime of elder abuse is prove that the suspect defendant knew or reasonably should have known that his victim was over 65. Now, how do you do that? Well, there's one easy way. If the victim's driving a Buick, they must be over 65, right? So, you know, there are different ways to prove or at least demonstrate to a jury that this person should have known reasonably that his victim or her victim was over 65. Now, elder exploitation is one form of the crime of elder abuse. Amy has touched upon some of the others, but let's concentrate just on elder exploitation. And basically, what is it? It's theft committed against anybody over the age of 65 that the defendant knew or reasonably should have known was over 65. And if the loss is over 950 bucks, it's called a felony. If it's under 950, it's a misdemeanor. Now, who are the usual suspects? Actually, who are the unusual suspects as well? I've added that too, because over the course of my career of prosecuting elder exploitation cases, I have been surprised, somewhat shocked at the type of defendant that I have prosecuted. Yes, we've prosecuted lawyers. We've prosecuted realtors. We've prosecuted financial advisors, as well as your typical dirtbag, scumbag that you're thinking of. But they come in all shapes and sizes, all different backgrounds. And we should never discount the possibility that somebody that maybe that we know well could be doing this. I'll never forget that one of our own team members in our multidisciplinary team that we formed many years ago for elder prevention, she ended up as a defendant stealing from her multiple clients, and we had no idea she had a gambling problem. So who are the mandated reporters? And many of you on this call, or some of you at least, are mandated. Some people don't even know they're mandated reporters. For example, how many clergy do you know in California? Many of them don't even realize that they are mandated reporters of suspected elder abuse. Obviously, any care provider, whether paid or unpaid, any medical provider, any first responder, but there's also every single person who works in a financial institution is a mandated reporter of suspected financial exploitation of an elder or a dependent adult. There are other people that I think should be mandated reporters, such as notary publics, but unfortunately, Governor Brown, as he was then, nixed that legislation that we put together. Now, this decision-making of, is it just a civil matter or is it a crime, is too often in San Diego County being made by the wrong person. And what I mean by that is it's often being made, in fact, 95% of the time, it's being made by law enforcement. And I spent 22 years trying to convince law enforcement, you are the wrong people to make that decision. Why? Because anyone who makes a decision, whether it's civil or criminal, has to do it by way of a background in that field. Law enforcement generally are not lawyers. They don't know the fine tuning of the law. They do not know the difference between civil and criminal. They think they do, but they actually do not. The only person who is qualified to make this call is a trained prosecutor who's had training in and prosecuted many types of different fraud cases. But the problem is the public go to the police, they try to say there's been elder exploitation, and what happens? They are told it's a civil matter. So I constantly tell people, write a letter to the police chief, to the sheriff, write a letter with a copy to the district attorney's office, and let them know that you feel that this decision was made by the wrong agency, that it needs to be made by a prosecutor. Now, the impact that COVID has had on elder exploitation is immense. Let me just tell you a practical example of what I'm talking about. Most suspects who are arrested, say today, on a charge of elder exploitation under Penal Code Section 368, what will happen to them? Well, almost every single case, they will be bailed out. They will be released from jail by the judge, if not also by the jail themselves. Because there's this unwritten rule that if you're not a violent criminal, if you're not a danger to, quote, the public, then we're going to release you. And what happens? We're going to release you. And under the current restrictions in the court system, the chances of an elder financial felony case being heard in the courts is being put back by months for a preliminary hearing, and for a trial, probably over a year. Now, what happens? You've got a victim in their 90s who memory is failing. The evidence is going to get weaker and weaker as time goes by. So we're seeing a lot of impacts of these cases. And what's happening? It's providing predators with more opportunity to go out there and do it again. Now, how can you help in the fight against elder exploitation? One very, very effective means is by being part of what I call an elder exploitation multidisciplinary team. You know, we started this program 3 years ago, just before I retired from the DA's office. It's called Elder Protection Council. If you're not already a member of it, I urge you to email this lady here that is in the bottom right-hand corner, Linda Moy. So it's linda.moy@sdcda.org. ask to become part of the membership of the Elder Protection Council. Right now, they're meeting virtually. They will have another meeting, I think, in June. And we need more and more people from different professional backgrounds to be part of this council. And you can help by raising awareness, by enhancing prevention and improving protection, being part of this team. I'm a total believer that when I stood in front of a jury and gave an opening statement in an elder exploitation case, I was conscious of the fact that I could only do that because of a team behind me. Adult Protective Services, a mandated reporter, a dedicated detective, a forensic accountant, a neighbor, a member of the clergy, whoever it was who made that call, who got the ball rolling. So I hope that we can all encourage awareness training. If you feel able to, maybe you could sponsor a program, a seminar, something like this, but for your own clients, for members. I know I just did one a couple of weeks ago with San Diego County Credit Union on romance scams. And during that seminar, I was able to reach out to several people who unfortunately had become victims of the romance scam. So there's a lot that we need to get involved in. I'm going to leave you with my contact information. One of the things we have got to do is to make sure that law enforcement knows when you are serious about wanting a case to be investigated. Sometimes, as I say, they'll make the wrong decision. Sometimes they will also interview the victim and make this mistake of asking the victim, do you want to press charges? Now, that is totally inappropriate question because victims never get to press charges. TV likes to think that's the case, but it's not. It's not factual, it's not legal. The only people who get to press charges are prosecutors and not the victims. So if there's evidence beyond a reasonable doubt of a crime of elder financial exploitation, contrary to Penal Code Section 368, and if a prosecutor believes they can prove that to 12 people on a jury, then that case should be filed and hopefully will be, because San Diego County, I'm proud to say, is one of the leading prosecutorial agencies in the country on fighting the fight against elder financial exploitation. And I'm so happy that after I left, I was able to I mentored for 8 years a very talented younger prosecutor called Scott Perella, who's really doing a phenomenal job leading the fight against elder exploitation. So with that, I hope we've got some questions. I'm going to throw it now back to Paul, and I'll stop sharing my screen.
Thank you, Paul Greenwood, and everybody else on the panel. And you mentioned Scott Burlow, and I remember I always had you on my speed dial and my email to send questions or elevate issues. Do you think he'd be willing to accept those types of inquiries? Absolutely, he would. And you know, certainly I would encourage people to also email me. I can be a funnel or a conduit. And I didn't actually say this, but I'm spending a lot of my time doing trainings for law enforcement and adult protective services around the country, but I also get involved in local cases with civil litigators. And if I can be a conduit to make sure that a case gets to the right law enforcement agency and to Scott, I'll be more than willing to do that. Fantastic. Charlene, would you please put up that slide? I just want to finish the last few chapters on a story that I told everybody when we were at Morgan Run back in 2017 about my dad. He fell victim to a lottery scam. My message then and my message today is if it can happen to him, it can happen to anybody. He spent 39 years as an accountant with the telephone company. At the time, he was doing 2 or 3 crossword puzzles a day. He certainly was not suffering from cognitive impairment, at least as far as we know. But he fell victim to this lottery scam, sent over $90,000 in cash to strangers and also about $10,000 in merchandise. The good news is that in 2018, we heard a story about a settlement that Western Union had with the Department of Justice, where they were going to reimburse victims of scams like this. So my wife, Joan, actually filed a claim on behalf of my dad in 2018. Fast forward to 2020, my dad received a check from Western Union, or actually from the settlement fund, for $92,000, which reimbursed him for all of the cash that he had sent to the scammers. So that's obviously a miraculous result and is not very typical, but it is a good result. So I just wanted to finish the last chapter on that story. And in fact, the final chapter is on February 13th of this year. My dad passed away peacefully without any pain and suffering. And but his story will live on. I founded a service called Senior Safe and Sound, which continuously blogs about elder abuse issues, trying to elevate awareness and help people fight this head on. So with that, we'll go to questions. I have one question for Rob. So we'll put Rob back up. Rob, for professional advisors, how can they help mitigate the risk of civil or probate litigation against them?
I think the main starting point should be whether or not someone is receiving an undue benefit. So if the elder is making some kind of a decision that benefits them, you should have less concern than if you're assisting the elder and harming themselves for the benefit of a third party. You should also be diligent and rigorous in making sure that you as a financial advisor don't receive some kind of an undue benefit. There are certainly cases involving financial advisors who are less than scrupulous, selling exotic investments with very high commissions that don't benefit the elder and benefit the financial professional in an incommensurate kind of way. And so I really think that's the starting point, is figuring out who benefits and just making sure your loyalties are aligned. Listen, does it get dicey? Absolutely. I mean, if you're managing the finances of an elder and they come in and they're insistent that they want to execute direct beneficiary designations over a tax qualified plan, and their trust attorney said, well, I don't do that, you need to go meet with your financial professional, and they say, listen, I want to execute this to disinherit Sally and to leave everything to Jim. Jim's great. Jim's here with me right now and Jim's telling me what to say. Well, I'm joking there, but you get what I'm saying. It gets a little dicier when there is an undue benefit, but the elder is somewhat insistent. And I think that one way for you to protect yourself would be to have multiple meetings. The cases we've had that have been more hard fought than others involve elders having several meetings with their advisors and the advisors making several determinations that the elder knew what they were doing and weren't the subject of undue influence. So I would say, if you're going to unduly benefit someone, don't do it hastily, and make sure that you've got a very thick file as to why you reached your conclusion.
Thank you, Rob. And for those people who can do this, you can also ask the client to give you a trusted contact, someone that's in their close inner circle that they trust, that you might be able to bring in to bear. One of the questions that came up is that fund with Western Union and the Department of Justice still active. The fund may be active, but the deadline to make claims has passed. Question for Amy. So let's bring Amy back on. Amy, can you tell us, how can people be aware of what the latest scams are going on these days?
Well, I put in the chat box the website for the San Diego District Attorney's, County District Attorney's Office. There's a bunch of links, just all kinds of helpful links for both local resources and then national resources. Also, the banks and credit unions are starting, I'm noticing they're starting to have more education to the members about the different scams. So there's just there's a lot of information out there. You just have to go to these links and do a little research. But there's a lot of information, and you can start with that website that I put in the chat box.
Thank you, Amy. Paul Greenwood, question for you. So now that you're retired, put that in finger quotes, and we don't get to see you as often speaking on the circuit in San Diego, tell people how they can find you and how they can continue to get your wisdom and the messages that you want to send out there.
Well, thank you. Yeah, so I've posted my email address and my cell phone number on the last slide there, which you will have. And you know, during this pandemic, I've actually done 65 webinars across the country. I've been so grateful and appreciative of the opportunities, primarily through AARP, Anti-Fraud Watch Network. I've also done some local webinars. I mentioned the one with San Diego County Credit Union, but if you see an opportunity or a need for me to give a presentation for seniors online, on Zoom or whatever platform you choose, I'd be more than happy to do that. I have this presentation called 15, I used to start with 10 top tips. Now it's 15 top tips on how to prevent yourself from becoming a victim of elder abuse. And that seems to go down pretty well. So yeah, feel free to contact me, even if it's just for a little bit of information. I'd be happy to do that. Just like Pete said, no charge. But if you need something more along the lines of a formal opinion, or I'll be more than happy to discuss that with you.
Thank you, Paul, and thank you to the rest of the panelists, Amy Wasak, Rob Derringer, and of course, Paul Greenwood, for a wonderful panel discussion, very informative, very thorough. I think we'll continue to do these from time to time. I want to alert people of next month's meeting. Next month is the community foundations. So we have a representative from the San Diego Foundation, the Jewish Community Foundation, the Rancho Santa Fe Foundation. I was reminded that this is backed by popular demand. It's always a very popular, very interesting panel discussion. And one of the people, John Jenkins, thank you for answering one of the questions about protecting yourself and having other people in the room. So if you just want to read that answer in the Q&A, thank you, John, for posting that. Question here for from Sally Bergman to Paul Greenwood. What's your email? Maybe you could just type that into the Q&A, Paul, if you would. I'll give a moment for that to happen. I want to again thank the Jewish Community Foundation, Charlene, and your entire crew for putting this on. Wonderful job behind the scenes, as usual. You just work like magic. Thank you so much. Thanks again to the board of the North County Estate Planning Council. I've enjoyed standing in Bill Super's shoes. They're big shoes, but hope I was able to do okay. Charlene, did you want to add anything?
No, I think that's fine. Just to say that everybody should have received the materials by now, which does include the contact information for each of the speakers. And if you have not received the materials, please reach out to Bill and he will forward them to you.
Okay, I think with that, we'll close the meeting for today, and we'll look forward to seeing everybody next month. Thanks, everybody. Have a great day.